I'm extremely delighted and honored to have with us Mr. Vikas, who is a graduate from NLIU Bhopal and with more than 10 years of industry experience. He's currently working as a partner at Cyril Amarchand Mangaldas and is also an advocate on record at Supreme Court of India. It's a pleasure to have you with us today, sir.
Thank you both. It's a pleasure for me as well.
So would you like to take our viewers through your journey? Like that was your introduction from our perspective and based on what we could gather out of your LinkedIn profile. But would you like to tell our viewers how did you get into law? Like, was it accidental or was it a like deliberate choice?
Okay, yeah. So for me, it was not a deliberate choice for sure, because I was preparing for medical and I came to Delhi University. I was in Delhi University for a year. I was pursuing geology honors. So you see, it's a completely different field altogether. But when I came to Delhi in around 2005, thereafter I came to know honestly about the national law schools. And at our time, there was no CLAT. So some of the friends suggested, and at that time, the internet had just like sort of, at least in Delhi, it was quite a lot over there. So I went to a cafe and just looked out for like, career opportunities after 12th or things like that. Of course, I am from Bihar, and therefore my aspiration was also to go for UPSC. But and therefore I had joined Delhi University because it's a good ground to do that. But then I got to know about this law schools, and the curriculum was quite good. So, and it was an integrated course. You get a graduation degree as well as a law degree. So I gave exams of few national law schools, including Bhopal. And despite the fact that there are only 50% seats for outsiders from MP, but I was fortunate that I got through, and then um, yeah, so it was purely by accident. It's not deliberate at all.
That's even if accidental, that sounds like a very interesting journey, when you ended up choosing law in the very first place. And for more than 10 years now, you have been into this journey, and
Yes.
hopefully for many more years to come, that you stay with or in law forever.
Yeah,
So,
yeah.
sir,
Lawyers don't retire, you see.
yeah, exactly. So that was the point. Lawyers never retire, even though we stop working, our mind or the mental clock never stop working for lawyers. So,
Correct.
sir, I think that goes without saying that as a partner, in a law firm comes a lot of responsibility. And our
True.
viewers someday aspire to become one. So, can you take us through a day in a life of a partner for such a immensely great law firm?
So let me just take a one step back before we get into the aspect of what are the expectations in life of a partner. Let us say the life of an associate at a law firm, rather, and then of course we will go to that step as well. See, of course, Cam, when I joined, it was Amarchand Mangaldas. It was an undivided firm in 2011 in its Bombay office, right after college. So it's in fact more than 11 years now. Uh, but when I joined, I got to join into the litigation team there. All the law firms, like big tier one law firms, have a lot of practice areas, not just litigation. Here they call it disputes practice, which is like includes court litigation, includes arbitrations, and a lot of things like that. We have capital markets, we have project finance, we have teams dealing with tax, teams dealing with real estate, teams dealing with general corporate. So it's a wide variety of lawyers. Broadly, we can put into transactional lawyers and then litigating lawyers, right? So I always wanted to be in a litigation disputes team, and I was fortunate that the firm gave me that opportunity. Bonus is not just to grow and develop yourself, but take a team with you. There are associates, senior associates, principal associates who are with you. You have to see that they're also growing or getting clients. So there are a lot of things, and it's not just about executing work. It's about actually getting work. So, and also listening to your clients, then going to a court, and then hearing judges. So there are a lot of things which goes hand in hand. It's of course looks very lucrative from outside. It is lucrative also. I'm not saying it's not, but sometimes you have to experience it to actually feel what it is. Um, Looks glamorous. It is not like Harvey Specter for sure, the, as you see in Suits or Ross. I haven't come across an associate who's like Ross. Neither have come across a boss who's like Harvey Specter. But yes, you do sometimes comes across certain matters or certain experiences in in your own matters or in court, which of course gives you a sense of satisfaction that you are a part of some big matters where you're able to get justice for a client. Don't get into justice in terms of criminal matters and all, because firms, usually top tier firms, they don't participate in hardcore criminal matters. Usually, they would be involved in a white collar crime or, 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 or or crimes in relation to a company and big corporates. Like right now, you must be reading in news, a lot of people who are facing a lot of PMLA, of course, prevention of money laundering, because it concerns a company. It has some white collar crime perspective to it in certain cases, of course. So those things are there. Uh, the life starts at 6, 7 o'clock in the morning, and you don't know till what time in the night it is going to end. So if you ask, for a lawyer, it is very different, very difficult, not impossible, but little difficult to maintain a work-life balance in the initial years and even thereafter, because I have seen lawyers who get up at 4 o'clock in the morning and like senior advocates, and they're working late night. So, but it's quite fulfilling if you are satisfied with it. So that's there.
So since you have been a part of the dispute resolution team since more than a decade, and you're also an advocate on record in Supreme Courts, I would particularly like to direct this question towards you. A lot of students take up CLAT or they go into law school, but they have this feeling among themselves that I'm an introvert. What if I am not able to do good in law school? Or what if I'll not be a good litigator if I choose litigation as a career? So, is it really that introverts can never be good litigators, or it's just a myth and there are certain things that are changing around this perspective?
First of all, I think that once you have understood and realized that you are an introvert, please work towards it and don't be an introvert anymore. But having said that, I don't think that it's absolutely a myth. It's absolutely, if I may use the word, unnecessary to think and ridiculous to think that just because you're an introvert, you can't do well in litigation. Most definitely not. There are a lot of flamboyant people who may seem to be succeeding in life, but that's not the case. Introvert does not mean you are not competent, right? There is no correlation between being an introvert and being competent. Introvert would just mean that you do not express yourself as eloquently, or not even eloquently, as expressed potently as an extrovert does, right? There's nothing else. So in competence, there's no distinction. It doesn't determine whether you are competent or not. So I think a person who realizes or who understands himself or herself that I am an introvert should first of all not think like that. Even if they think like that, they should not think that they can't succeed in litigation. In fact, in litigation, what all you need is hard work, I think determination, and meticulousness, which you need, I think, in any other area of life or law or personal or professional life, in any life where you want to succeed. And I think that the which we call in law as a grand norm. So being honest to your work, being determinative, meticulous, it's applicable everywhere. And I don't see why would you not succeed if you are just an introvert. So what? Introvert is more on the grounds of personally you are not as vocal as, let's say, an extrovert is. But when you are fighting for a client, let's say as a litigator or a person or an individual, you are presenting their case. What it has to do with you being introvert or an extrovert? Just a question I am posing to myself and to them who thinks like that. So I don't think your nature. See, of course, in the kind of world we live, your wholesome personality makes a lot of difference in terms of your both professional and personal success, whether you are successful or not. But I don't think it's a determinative factor. it may add to, if someone is an extrovert, it may add to their personality because they can go and talk to anyone. They can go and find out information. So of course, it's a plus point, I would rather say. But I don't see that it's a deal breaker for you to become a successful litigation lawyer if you're an introvert. And if you do, then you work on it. Uh, so yeah,
I think so. That's the simplest way of putting it through. That just work on whatever you feel it's wrong. Okay.
not wrong as in
Hmm.
personality. Yeah, well, wrong is a strong word, I feel. It's
Hmm.
sometimes I am an introvert, so one should not have an attitude of so what, but an attitude
So.
of that if I think that I'm an introvert,
Hmm.
and let's say my goal to achieve in life is something which needs me to change that,
Hmm.
then I will work on it.
Work on it. Yes, it's all about working it through. I mean,
Yes,
there's
yes,
nothing as such of that nature which can't be improved eventually with time.
absolutely,
Okay, correct. So, sir,
absolutely.
in litigation per se, there's this perception that we have so many ways of going into this field of law, particularly. You can join a senior advocate, you can start with a department in a law firm, you can start with your own practice. So, can we
Yeah.
narrow it down, even if it's possible to one particular thing, or if someone wants to go into litigation, which pathway they should choose or go forward way, or anything will work?
If you give me the liberty of rephrasing this question, I would not say that we should narrow it down.
Hmm.
I would rather say you should broaden it. Why I'm saying this is the reason is this. See, sometimes, of course, we all say that there is that whatever a person wants to do, he or she can always do if they have the determination to do it. While having said that, I also believe in uh, your situation, your practical situation, your financial, economical situation, and all those factors are also there when you come out of college. Let's say if someone has taken a loan, now they want to pay the loan, of course, before they start. So law firm is a good place because law firm is going to pay you well in the initial years. But let's say if you go and join an independent practitioner and all, you may not get that amount of a salary or monthly remuneration or whatever they may call it. So these are practical aspects. Of course, with your sheer determination and hard work and all, you can come over everything. Of course, all of us listen all these things. But in fact, today only I was having this conversation with an intern this was the last day today. So she had come to me. She's currently studying in NLS Bangalore. She was asking me as to how should one go about it. And generally, we were having this conversation. In fact, this conversation only that how one should go about it. So I said, see, I can't give you an absolute answer. It will depend on your uh, what do you want to do in life? That is one. What are your financials and social and all those situations that you can determine? What is your temperament, most importantly? See, sometimes you may be a brilliant person in speaking or, orator, but you may not, and that an assessment you can make if you are very neutral about yourself. Or sometimes you can be very good at drafting, but not so good at speaking. You can work on it, of course, but some people are gifted with speaking skills. Like you will see that Vivekananda was a great speaker. Like he could speak and mesmerize the audience, right? Not everyone is a Salve or a Ram Jethmalani or a Gopal Subramaniam or a Dr. Singhvi, because we see them on a regular basis in courts, and you see how crafty, how eloquent, how brilliant they are. See, there are a lot of people who will be brilliant in law, but how to present that law to take a desired, uh, I would say that get justice to your client, at the same time get desired result from the court for your client is an art, right? You would be hearing that cross examination is an art. How you cross examine a witness or a person, right? So what I'm trying to say here, I will go back to that question. I can't give you an answer that to narrow down it,
Hmm.
but what I can say tell you that first you will have to make an assessment as to what you want to do in life and what is your temperament. Both things are important. Let's say uh, I have taken arts in 10th and 12th, and after passing 12th, I want to now become a pilot. It's not possible. It can be possible in an exceptional circumstances, but I don't want to get into an exceptional circumstances. I have taken arts, I've studied it, then I did my graduation also, let's say in commerce, and now I want to become a statistician, a mathematician, or let's say a scientist in NASA. It may not work. So what I'm trying to say that you will have to keep in mind your temperament, your expertise, your caliber, plus what you want to achieve in life. And specifically coming to this specific aspect of a litigation, I always give advice to a person that if you want to become a traditional, a hardcore litigator, my personal advice would be that you join a chamber, preferably a district court or high court lawyer who has a good both filing and arguing practice. Because in top tier law firms, the opportunity of you going in court and arguing are very less. You will get to be on a very good matter. You will get to be on high profile matters. So the learning curve is actually very high. And of course, you have a firm setup. Like firm provides you with a lot of infrastructure, right? So you have all the facilities at your command. But there are these limitations. You can't go and argue in a court, right? You may not go to court that frequently as you will go if you're with an individual advocate. But again, you will have to identify the kind of individual advocate who will give you this kind of exposure, who will actually expose you to a court and will tell you, okay, don't worry, what so if you're 6 months into the profession, go to a court, argue out this application, or go and take an adjournment, or go take a date, whatever. So this also you will learn when you are on the ground, right? These are, I would say, these are ground realities. I would say start with a firm, see if the firm suits you and the kind of work. So firm to firm differs. Even in a firm, it depends from team to team. You know what I'm trying to say. So I can't give an absolute answer, but it will depend. If let's say you want to become a very good international commercial arbitration expert, firm makes sense because individual lawyers will not have this kind of work. But let's say you want to become a very good M&A lawyer, you join a firm. You want to become a very good project finance lawyer, join a firm. You want to become very like you want to get into very company law, do an IPO and things like that, join a law firm. But let's say you want to go to court and you want to argue a constitutional matter or a contractual matter or whatever it is, join a chamber. So depends on what you want.
What?
Yeah.
Just a
Sorry, I
follow-up
think it was a
question.
lengthy answer, but
No,
I
no,
thought
no.
I had to drive this point.
So just a follow-up question, which I think a lot of people might also face when they're in law school or they have just started litigation. So if someone has started as a litigation through chamber, and later if that person wants to switch to a corporate and join a firm, so is that feasible for that person?
It is very, it is most definitely feasible.
I think your video. Yeah.
Yeah, can you? You can most definitely. It is feasible, but I'll give you a very simple example. I usually like giving examples. Let's say you're traveling in a car, and all of a sudden you want to switch to a bus. It's little difficult. Let's say you're traveling by a train, and you want to switch a train. Train will stop at station, and it's easy for you to switch to other train and go. But let's say you're traveling by train, and now you want to catch a bus, then you will have to get out of the station, go to the road, take the bus, and go. So what I'm trying to say by this example, that when you are in a firm setup, you are groomed in a specific manner, right? When you are in an individual chamber, the grooming is different. In fact, when you will speak to a lawyer who does litigation in a firm, and when you will speak to a lawyer who is an individual advocate, their approach will be different. You can sense it, you can see it, you can perceive it. In fact, in a firm only, if you will speak to a lawyer who does litigation and a lawyer who does transactional work, their approach is different. What I'm trying to say by this is the transition is smooth if there is not a lot of differences in the approach, but the transition takes little bit of it's little requires more of labor and adjustments when you are making from one to other. So if you want to shift from a firm to firm, it is easier. If you want to shift from a chamber to chamber, it is easier. But if you want to change from a chamber to a firm and vice versa, it's little difficult, but it is not, it happens. And also it depends of how much of time you have spent in that particular area. Let's say you have been in chamber practice for 10 years and now you want to shift to a firm, very difficult. So it also depends the amount of time you have spent. If you have spent, let's say 1-2 years, very easy. Vice versa, because in 1-2 years, not much you have not lost much, or not you have not gained much, or you have not hardened much. Because if you are in a specific format, you get conditioned in that manner, right? If I am in a firm for 10 years, I have got conditioned in this manner. Now, if all of a sudden I want to shift, I can of course shift. There's no problem. But it will take some time for me to come at the same level with someone who has been 10 years in the individual practice, right? And exactly vice versa. I know what exactly the firm culture is, the firm structure is, what are the expectations of a client and how to manage them. Expectation management, right? A individual lawyer will also know it, but not with the same calibration as a firm lawyer would know. But there will be a difference. So uh, difficult, but not, and it happens. So it's not something which is unheard of. A lot of shift happens.
On that note, like a lot of our viewers are still, first, second, third year law students who are just still navigating through their law life. And you are currently now on both side of it. You are partner at a law firm and an advocate of record as well. So, in your terminology, or if you could explain in a very simple terms to our audience, are they two backgrounds mutually exclusive of each other? What the roles and responsibility of AOR is, or a partner in law firm is, or they go both hand in hand?
Also, I'll answer this question. See, as if I gave AOR exam because I was initially in Bombay for 5 years, and then after that I shifted to Delhi. Once I shifted to Delhi, most of the work I was doing in High Court and Supreme Court. And then I realized that AOR are basically a special class of lawyers
Hmm.
who give an examination conducted by the Supreme Court. And once they clear, they of course get a certificate. They are the only class of advocates who can do a filing in Supreme Court. So not any and every lawyer can come and do a file of wakalatnama in court. It has to be an AOR and AOR only.
Hmm.
They also have the right to argue and brief some external counsel who can argue before the court. So this is the advantage. Uh, other advantage is that when you are in AOR, you understand the intricacies and the procedure which is followed in Supreme Court. That is another. These being a partner in a law firm and AOR, uh, it's not necessary for a partner, litigation partner to be there, not at all. But it's adds to your uh, personality and adds to your sort of, if you are doing mostly Supreme Court work, you can pitch into a client that, while of course I will help you and I'm also an advocate on record with Supreme
Hmm.
Court, that gives him the confidence that this person will know the ground reality of Supreme Court, will know how to do the file. So all of these, but it is not a mandatory requirement at all. I did it because I thought uh, adds to it.
Hmm.
And tomorrow, let's say you want to go independent, for example, then you have an added feather with you, right? You can go into filings. Not everyone can do. These are not connected, to be very honest. Uh, let's say, what if you're a transactional lawyer? Doesn't matter. If you are practicing mostly in NCLT or in CLAT, which deals with the Companies Act, where
Hmm.
you are dealing with matters arising out of Companies Act or IBC or things like that, you don't need to be an AR. A lot of lawyers are not AR. So, but if you intend to practice in Supreme Court,
Hmm.
then it makes all the sense to be an AOR. And for the students, I must tell one point, who are in first, second, third, or even fourth year, I will say one thing, that and a lot of time we learn from our own mistakes. You or I may say a lot of things, but ultimately they will do what they will do in college. And once you come out, and then you realize, and you hit the reality. But and this is not I'm not going to say anything new. It's the age-old thing which I think everyone has been saying. Our parents also say there is no substitute for hard work. Absolutely. And in law, most definitely not, because in law you have to keep reading, and understand. But what I think that and nowadays, with the kind of technology and the kind of information base we have, a lot of opportunities we have, so much of exposure in terms of both national and international. Read as much as you can. Be honest to yourself and to your study, and have a good command over few law for sure. Like, read Contracts Act very well, Read constitutional law very well. It will help you in whatever sector you go. Whether you become a transactional lawyer, litigation lawyer, you go to a PSU, or you go to a company, you become a lawyer for a company, or you go anywhere. Transfer of Property Act, Companies Act, um, little bit knowledge of CPC. If you want to do litigation, then CPC, CRPC evidence, these three are most crucial acts. So try and read. See, I know how even in national schools they teach you, but try and read these books, the Bare Acts. You just read the Bare Acts. Of course, commentaries are good, and of course, you must read commentaries in law. Nowadays, because in our times it was not that, but now you have live law, now you have bar and bench, so many media agencies which keeps on publishing a lot of articles and all. Supreme Court has now started has its own website and started to now publish the judgments which it passes. It is available to accessible to all of us. Read case laws. Case laws are the best way to know, learn, and appreciate law, because ultimately it is the highest court which is going to interpret a law at the end of the day. So, and they also, as our courts are in the habit of writing lengthy judgments, you get to know the entire background. You get to, it's some, for some aspects it's good, for some aspects it's not so good. But let's say there is judgment on Puttaswamy. Now, if you read Puttaswamy, you will get the entire idea on what is a right to privacy, right? What to right to life, interpretation of constitution, why a law should be made, and what grounds a law can be held to be ultra vires the constitution. All the principles of LNR are there. So what I'm trying to say that judgments will the amount of knowledge a judgment can give you in you just reading this 500-page judgment, you may not get from reading a constitutional law act, bare act, or something like that, because there you will understand it to the best of your competence, which in college will be, of course, not that much as much as a lawyer or a high court, Supreme Court judge who is having after decades of practice. So in college, read judgments, and read judgments, and be in touch with your alumni, because they will be sort of telling you the experiences and realities. Communicate, be in touch with whosoever you know who are working, and be guided by them. Today is very easy, right? You have WhatsApp, you have email, you have a number, phone number you can call. Yeah. For them, my advice is be honest, be meticulous, read judgments, and communicate as much as you can.
You know, as much as I'm liking this conversation, and I wish it goes on and on and on, but at this point, I think I'll just ask you two final questions.
Yes.
One, it is always said that law is a practice. You never perfect the art, you keep on practicing throughout your life. So,
Right.
I would like to ask you, do you still get nervous while arguing or while representing your clients at times? And secondly, sir, one more thing. Okay, are there any books that have really helped you as a lawyer and you would like to recommend to our viewers?
See, I think books is more of a personal choice. So I think, and people may or may not agree. I think reading Bhagavad Gita helped me a lot. But so that's a very separate thing. But I think you can read Before Memory Fades by our great lawyer Fali Nariman, or Nani Palkewala, The Courtroom Genius, very brilliant book you must read. Or in fact, there is I was just reading it today when I thought I must suggest that there's a book by Jia Modi on 10 judgments that changed the framework in India. Or there's a book by Ashok Ganguly called Landmark Judgments That Change India. A lot of books. There's no dearth of good books, but I think judgments, I would say to a lawyer, judgments also are a very good read. And yeah, and as far as getting nervous is concerned, I think I don't get nervous, but of course there is some level of anxiousness, maybe because sometimes things are not very predictable. And okay, it depends on your level of preparedness. If you're prepared, in my view, you don't get nervous. But I don't. It depends on how. What do you mean by nervousness? Uh, I don't get nervousness usually, but I think that is also because now I have been appearing on a regular basis before court. But initially, yes, like in first when you start feeling like thirsty, you want water, it happens. But only in the initial 2, 3, 4 months, 5 months, 6 months. That's all. Not now.
Thank you so much, sir. It was a great session. Thank you for taking
I
your
hope so.
time out. It was a great session, and we really hope that our viewers who are aspiring to become litigation lawyers or even go into this field might have got a lot of things to learn and start their journey head on. Thank you so much, sir, for taking out time and having this conversation with us.
Thank you so much. Best of luck to you guys as well as to the viewers. All of them.
Thank you so much, sir. Thank you.
Thank you.